Welcome everybody. We're just waiting for everybody to arrive and then we will begin. We're expecting around about 50 people and so the numbers are rising. We'll start when we get close to that number. Hi Charmaine, good morning. Good morning to everybody. We know we have lots of people in our participant group today who we have trained as mediators and who we know well. I wish we could see you and say hello, but lots of very familiar names there, so welcome. I think one of the things we're very consistent with in conflict dynamics is starting on time and sticking with time. So I think we will stick with that tradition and start. We're on 41 people, which is a good number to begin with. So welcome everybody to our webinar today. It is almost a year to the day that not only did Rule 41A come into effect, but we also in conflict dynamics produced a number of blogs. John Brand wrote a number of blogs which are on our website about what we could expect. And we held a number of webinars as well about what we thought we were in for. But when I look back on those webinars and look back on the blogs, it was all rather theoretical. It was what we were hoping for, what we thought would happen. And now a year down the line, we have some experience. And our experience comes from different sources. Our experience comes from within conflict dynamics, where we are setting up Rule 41A mediations increasingly. Our experience comes from our mediators, such as Michelle and Lee and Lizelle. It also comes from the attorneys, and Lee is going to be talking from the attorney's point of view. And then Lizelle is well positioned to talk about the rule and its intention and what we still hope for with the rule. So with that brief introduction, I'd like to just explain a couple of protocol matters. We are recording because we like to put the webinars on our website for people to watch later, anyone who couldn't attend. And then I'm going to turn to Craig to just highlight a couple of aspects of the Zoom protocol. Craig, are you there to do that?
Yeah, Felicity, I thought we were going to skip this. I'm just hiding now in the background.
Well, okay, all right, yeah, go ahead.
Yeah, good morning, everyone. I see that there's been a question raised about, can you see me? It's a webinar format, so we won't see anyone else but the panelists. You can speak and ask questions and raise your hand and send messages in the chat. So all those functions on the bottom of your screen, you'll see the chat function, a Q&A function as well, and you can raise your hand, or else just unmute and ask a question. Generally though, please keep yourself muted. We don't want to be disturbed or disrupted by background noise, which may happen. Yeah, anyway, we'll see you. Thanks very much for joining us.
Great. And although we have presentations to make, we'd like it to be interactive. So as Craig says, please use the chat or the Q&A. I, as the host, will keep an eye on that and ensure that the speakers are alerted to relevant questions or questions relevant to them. Right, Craig, could we have the second slide? And that is just to give us an idea of the agenda and for my colleagues to introduce themselves briefly. And so there we have it. I'm a director in conflict dynamics and very much involved in the mediator training, and I'll be hosting the session. Lizelle will go next. Lizelle, can you briefly introduce yourself?
Good morning, everyone. My name is Lizelle Roos. I have a very long history with mediation, conflict dynamics. I started my training initially as a quarter next mediator, and then I did all the bridging courses. I'm also busy with my doctorate at the University of the Free State, where I look at also at mediation, alternative dispute resolution, and I am also accredited at CDR London, UK. So that's me in short.
Thanks, Lizelle. We will then be followed by, Lizelle will be followed by Lee. Lee, could you introduce yourself briefly?
Sure. Good morning to everyone. My name is Lee D'Souza Spagnoletti. I am an attorney and mediator. I've shifted quite a bit into the mediation space, and I've become a bit of a poster girl for mediations. So, you know, my experience lies in the mediation arena as well as the legal, or I should say the attorney arena. And yeah, that's pretty much me.
Thanks. And then Michelle will follow with a mediator perspective.
Thank you. Good morning, all, and thank you for being with us this morning. My name is Michelle Posman. I'm an advocate by training, a mediator at heart. Would love to be a full-time mediator when this rule gets traction, and I'm looking forward to that time. Mediate largely in the RAF space, employment and labor law space, and medical negligence, and a bit of commercial. A panelist on conflict dynamics panel and on IQUITATE dispute resolution services. And that's me in a nutshell. I look forward to chatting to you later.
Thanks, Michelle. Well, we wanted to find out a little bit about you, our participants, just so that everybody knows who's in the room. And so we have two quick polls, and in fact, it's not so much about you and your professional background, but you and your experience as a in mediation. So Craig's going to put up the first poll, which gives you an opportunity to say if you've ever attended a mediation, a civil or commercial mediation, so not labor management, but civil and commercial mediation, and in what capacity did you attend? So if you could just indicate by ticking one of those boxes, that will give us a good idea of your experience of mediation and how many mediators there are in the room and how many lawyers there are in the room. If you've done both, which no doubt people have, then choose the one that you've done most. Craig, have we got any results there? Great, okay. Lots of mediators, some representatives, and very few parties. Okay. And interestingly, not attended a mediation at all. So there are some people here who really are looking for the basics and nuts and bolts, others who are looking to how to participate in mediation, particularly with reference to Rule 41A, and that was really our purpose. We want to get to the nuts and bolts, and then how do you engage with this rule so that we can really get it going. And our next question then focuses specifically on the rule itself. So Craig, if you just go to the next question, not the, yeah, there we are. Have you attended a civil or commercial mediation in terms of 41A? So it's interesting to us that it's taking quite a while for the mediations to come through, the 41A mediations. It's difficult to know, obviously we don't know about all of them, but based on what you say, it'll be interesting to see the uptake. Okay, all right, let's end the poll. And yeah, I think that confirms what we think, that on this poll, only 4 people have actually attended a Rule 41A mediation. The balance haven't. So the uptake is slow, and hopefully some of our questions today will give you answers to how we can all really put our shoulders to the wheel to get this going. Now, because we have, and we anticipated we'd have a couple of people who have not been in mediation before and perhaps even haven't attended mediator training, we wanted to ask a question about what mediation looks like. So we're going to show a slide, and on the slide is there are 4 diagrams of 4 different dispute resolution processes. And we'd like you just to look at those very carefully, and then Craig will again put up a poll for you to vote which number is mediation. And then we'll confirm which one is mediation and just dispel any doubt that might come through about that in the poll. So Craig, let's have the poll as well, if you can multitask. Right. Okay, so the results are coming through thick and fast. And I don't want to reveal anything until we've got just a few more. All right, this is a slide we use on our mediator training at the beginning, just to make sure that people are on the right course, that they're there to do and learn what they had in mind when they booked. And yes, let's share the results. So clearly, the majority of people see that process 2 is mediation, and that's absolutely correct. And we intend with process 2 to demonstrate that there is a joint meeting in the middle. The mediator works with the parties in a joint meeting, and that joint meeting actually is a replica, in a sense, of process 1, which is negotiation. So mediation is a continuation of the negotiation process. And then the mediator in process 2 also works with the parties privately in side meetings, private meetings that are confidential, hence the little half bubble. And the mediator then moves backwards and forwards. And the role of the mediator is essentially as a process manager, making decisions about when to bring people together, when to talk to them separately, and facilitating that negotiation. Point number 1, or process number 1, is not a mediation because there is no third party, unless the third party, the mediator, has stepped out to have tea, but clearly it's very different from number 2. And 3 and 4 were meant to indicate adjudicative processes, which are somewhat more formal. There are no private meetings, and there are a lot of extra people in the room, like witnesses and even the public in number 4, which we intended to mean court. So mediation is a private process, confidential process, very flexible, and managed by the mediator, who facilitates the negotiation. If you haven't done our course, come on the course, learn more, and learn how to do that. Good, so let's move on now to Lizelle. And Lizelle, Lizelle's going to focus on the rule, exactly what it involves. And if you have any questions as she's speaking, just pop them into the Q&A or the chat, and we'll pick them up at the end. Lizelle, over to you.
Okay, thank you, Felicity. I'm just briefly going to, for introductory purposes, just have a brief background to the mediation in South Africa. It's good to know that South Africa is one of the continent's fastest growing and developing alternative dispute resolution systems. The whole idea with mediation would be to give the broader scope of people access to justice. And government has already several years ago embarked on a strategy to increase awareness with regards to alternatives to litigation. This is due to the fact that our court rolls are extremely congested. One of the very good examples is, for instance, the road accident fund matters. Ideally, litigation in essence should be one of the last resorts to be followed, or that would be the idea. Now, legal practitioners, when they hear this, they all freak out and think this is the end of days. This is not the case at all. And it should be also noted that even though South Africa is a recognized leader in using mediation with regards to labor-related matters, we are lagging far behind when it comes to our civil litigation system and also when it comes to commercial disputes. Several years ago already, government has implemented court-annexed mediation, which is mainly, they mainly focus in the magistrates court system, regional courts, magistrates courts. And then Rule 41A, the purpose was there to also introduce ADR within the High Court setting. So there is, that is the reason why Rule 41A was developed and drafted and implemented. We are still in baby shoes, as Felicity indicated. So there's a long way to go still, and we are all as practitioners and legal scholars are still learning a lot. So it's quite interesting for me as well today in the webinar. I'm sure I'm going to also learn a lot from Lee and Michelle, who has more day-to-day experience with regards to Rule 41A. Okay. In short, if we can look at the rule, firstly, what practitioners need to understand is that mediation is a voluntary process, and that means that that practitioners can and parties cannot be forced to mediate. However, with regards to when the rule is implemented, when you there are two stages. Which you can encounter under Rule 41A, and this is when we issue summons, and then that includes the action and application procedures. What the practitioners then need to do is they basically attach a notice to the pleading where they then indicate that the parties must consider mediation. When they also engage the client for the first time, they are also obliged, or the practitioner is obliged to inform the client of the fact that they have the option of mediation. That notice is then attached to the pleading, and when it is served, the other party then is aware of the fact that they have the option to mediate. Once they received the pleading, they then have to indicate if they are willing to mediate, and if not, then they have to provide reasons if they are not willing to mediate. Yes, so the rule is quite self-explanatory. If the legal practitioners read through the rule, they will see that there is a standard form 27, which is the notice that, or the generic notice that can be utilized when they attach it to the pleading. And then there's also the second stage when mediation can take place is at any stage before judgment has been granted. So, for instance, the matter has already proceeded, and at any stage the parties are of the opinion that the matter is not ripe for hearing, or that they can either agree that they would like to see if they can come to an agreement to finalize the matter, then they can do either a private mediation through an accredited mediation company, for instance, Conflict Dynamics, or alternatively, a judge in the High Court can also refer a matter if the judge her or himself is of the opinion that a matter should not continue to trial, but a matter should really, the party should really apply their minds and then try to mediate the matter. And then also a very, very interesting thing that I've encountered is that a lot of practitioners understand the process of mediation to be similar to arbitration, and it is two different ADR processes. That is the main difference between the two. Practitioners tend to try to run a trial and want the mediator to act as an arbitrator, which is not the case. The mediator is a facilitator and basically there to facilitate the process. Felicity, I know there's two aspects that you wanted me to touch on. I don't know if you would want me to.
Yeah, just two particular, well, perhaps just progress to the next slide. Let's just finish the next slide and then let me pick up on my points and any questions anyone has.
Okay. While a mediation session takes place, it's important for the parties to bear in mind that any disclosures made during ADR proceedings remain confidential, and it is inadmissible in evidence unless it is provided for specifically within the rules and or discoverable in terms of the rules. What this means is that at no stage the mediator is a party to the proceedings. A mediator cannot be subpoenaed, and whatever is stated in the mediation session is absolutely confidential, and that is not brought under the judge's attention up until the end of the matter where it might become relevant with regards to cost argument, but that is something that will be discussed later on in the webinar.
Yeah.
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 So
And, sorry, go ahead.
When I refer to a multi-door courthouse phenomenon, that is actually a term that is utilized to indicate that that it is not a process that is traditionally like we are used to in the adversarial system, and that means that at any stage a judge can refer a matter outside of the courtroom and actually order parties to go and discuss the matter to try and resolve the dispute by way of mediation, and that is what the term is used, the multi-door courthouse phenomenon, in the academic sense.
Yeah. So I think what I'm getting from you, Lizelle, is that there are lots of routes to mediation, and that Rule 41A is an additional route. There are the routes through just voluntary mediation, so people just agreeing to go to mediation. There were the routes through a judge referring parties to mediation, and then of course there's a magistrates court system. But now in terms of 41A, that route is much more specified and much more set out, and you've described for us how that works, and there's a process that needs to be followed and various documents and forms and submissions and things that happen along the way. Now, what happens if there was a case, in fact, this was a matter that was brought to Conflict Dynamics recently, a case that was initiated pre-March 2020, and the party wants to mediate, the claimant wants to mediate. Would it happen under 41A, or would they just have to go the voluntary route or ask the judge to encourage the other party to go to mediation?
I would say it would depend on it would be a strategic decision. It would depend on the client. It would depend on the legal practitioner as well. So, and that would also depend on the type of matter that is in front of the judge. At some stages, the judge will intervene from the judge's side when the judge is of the opinion that the matter should be referred to mediation, and that it is a matter that's basically only wasting the court's time and costs, and it is expected of parties to really apply their minds and to really be serious to attempt mediation. It's really, it's not just, you know, it should not be just a box that's being ticked. Parties should be really serious and earnestly attempt to mediate, and you must be, as a legal professional and as an officer of the court, you must be able to provide the judge with your assurance that the parties really did attempt to mediate. Yeah, so when it is even if it is a matter prior to the implementation of the rule, it really does not detract from the fact that the parties must still attempt in a serious fashion to mediate in a professional manner if the matter so requires it. Yeah, so you're really emphasizing the point you made earlier about how the system has shifted, in that there really is now an expectation that people will attempt to resolve their dispute earlier and not be waiting all the way through to the steps of the court, or expecting that it's only litigation that will resolve it. Definitely, and I also must say legal practitioners must be very, very careful to not end up the day at the trial court and then the judge realized that this is a matter that could have been finalized 2 or 3 years prior already. There's already case law with regards to that. Yeah, yeah. Okay, and then the other question was the sort of later in the process, in a way the opposite or extension of that earlier question, and what happens if there's already a matter in process, and let's say it was initiated after March last year, but people weren't really very familiar with 41A, so no one did anything. So could they now initiate 41A? I'm assuming the same principles apply as what you've just told me. I would say so, and I would say at any stage a practitioner can request an opponent practitioner to mediate, and still, if they do not want to, they can still be requested to provide reasons why not. Right. I cannot see why that can be a prohibition. Okay. Well, I think Lee's going to address during her talk the point about, and Radhika Singh has raised this in the chat, is reasons for not agreeing to mediate, and also what happens if people don't mediate in good faith and take it seriously. So maybe we'll continue that conversation with Lee. Right, well, thanks, Lizelle. I'm sure we'll come back to you for some detail a little later. And so I'm now going to turn to Lee, who will focus on the rules from the point of view of the attorney and using those rules. Lee, over to you. Oh, Lee, you're on mute.
No, I haven't done that in a while. Thank you. Let me start from the beginning. So I think a starting point for me in relation to Rule 41 is just to talk about where the profession sits. And this is my perspective. I think I must qualify it by saying that I am, I do plaintiff-orientated work. I know there are very experienced defendant-orientated experts or legal practitioners in the meeting at the moment. So my perspective is most certainly plaintiff-orientated. And what I can say is that mediation is not on the lips of attorneys in the mainstream. One wanted to see how Rule 41A has panned out, and it hasn't taken off as quick as one might have wanted. Obviously, it's established in areas like family law and in labor law. And there are certain areas of law that are starting to take off quite a bit, but it's most certainly not in the mainstream at the moment. In the personal injury field, there are pilot projects. So the Road Accident Fund, and in respect of clinical negligence matters, there is quite a buzz about it at the moment. I'm mediating quite extensively in the pilot projects. So that's there. But I think the biggest issue for me is a lack of understanding. And this is not, I generalize because obviously there are attorneys who use mediation effectively. But the reason I say there's still a lack of understanding is I see it very much in the pilot project that I'm involved in with the RAF. I do quite a bit of practice management advice or consulting. And the most common question that I get is, well, what if we don't like the finding? Can we appeal it? And that's where advocacy comes in that there is no finding. And many attorneys are not aware of this. They don't realize that we're dealing with a process of assisted negotiation, and that in fact, it's, the mediation process is driven by the parties. And the mediator is not there to make judgments, and the mediator is not there to pass opinions. They're there to assist the parties in engaging effectively. So for me, that's really an issue when it comes to seeing this rule move forward quite a bit. In relation to the efficacy of 41A, or I should say the perceptions regarding efficacy, I sense that there's still a mistrust of the mediation process. And this stems from the lack of understanding that there is in the mainstream. Again, I'm not talking about areas of law where it's well established already. But there does seem to be a distrust of the process. And, Lizelle mentioned box ticking. And I have, to a certain extent, seen that where one does raise mediation, and I found it in the family law arena particularly. Okay, well, we'll do mediation and let's get it over and done with. And I find that very often there isn't a genuine will to trust in the process, but more a will to tick the box, because what we are anticipating is that when it gets down to the trial situation, there is the fear that the judges are going to force mediation on parties, and there's a will to tick that box so that doesn't happen down the line when one is seeking a trial date. So that's definitely what I've found. In relation to the current court system is under strain. It has been for many, many years. If one looks at the trial role, the personal injury arena, whether it be clinical negligence or road accident fund claims, dominates the trial role. And what one finds is that access to the court system is difficult, particularly in those arenas. You've got Y category plaintiffs who are performing an obstacle to get to the steps of court, very often having to assist the defendant in the preparation of their defense in order to get to the steps of courts. And I do believe that this is where mediation is going to take off. What we have seen is that the date around a mediation is a very, very motivating factor for moving towards settlement. So even in circumstances where the mediation itself hasn't taken place, one is finding in those arenas that there's huge motivation to settle, and that the mediation date is bringing about response very similar to that which a trial date brings about. So that in relation to process is also a positive. In terms of court directives and rules, there's no doubt that the changes to the rules are pushing mediation. Rule 37.9 specifically says, it empowers the court to make cost orders not only against the parties, but also against the attorneys themselves, if it's found that the parties have failed to a material degree to promote effective, disposal of the matter. And I think that Rule 37 and 37A, in combination with Rule 41A, is really, really going to bring about change. And there are questions, and parties are, particularly in my fields where I practice, in fact, in relation to family law and delictual law, that people are querying and people are questioning the efficacy of mediation. So it is happening. It hasn't happened as quickly as we'd like to, but it is happening. And, again, I must refer to Rule 37A, where it specifically said that the case management process is used in the interest of justice to alleviate the congested trial roles. So the motivation for mediation and the court's will to push parties towards mediation is definitely happening. There's no doubt. So, for example, Rule 37A11 gives the judge the authority to explore settlements. And in fact, this includes inquiring whether or not the parties have considered voluntary mediation. So that's outside of Rule 41A. Now, I can say that I procured orders for mediation prior to the enactment of Rule 41A, where the court has made it clear that they are willing to make an order. Whether or not we're going to get orders for mediation or orders for the parties to consider mediation is something that I don't think has really come out of the court system yet. But the reality is that 41A obliges the parties to say whether or not they want to mediate. And also then, if they're not prepared to mediate, to actually provide reasons for their refusal to mediate. So this is all going on. The question is, if one looks at Rule 3712, it says that the case management judge can place the parties on such terms as are appropriate to achieve trial readiness. And I think the question on many of our lips is the court going to use that to enforce mediation? And we don't really know, and I don't know if there are colleagues in the audience who have seen this, but I have asked around, and for example, in Natal and in the Cape, there's a very, very strong move towards pushing the parties into mediation. So there's no doubt that the courts are going to help us. And, the reason that's so important is, and I'll talk about it just now, is in bringing mediation into one's practice, I do believe that we're going to be helped by the courts. And it is already being shown in our courts, that judges are wanting the parties to look at ways of resolving disputes. And so many matters are resolving on the steps of courts. Like Lizelle said, it takes either a brave or a stupid attorney to simply throw out a refusal to mediate, because their reasons for their refusal are going to be scrutinized in the long run. And we know that from court decisions already. So I think what needs to happen is there's a definite need to change perceptions. And this comes from the profession and from the mediation field, is to put out advocacy there, and to put out and to explain to the profession, particularly the legal profession, how beneficial mediation can be. It's cost effective, it's quicker, and there's absolutely no doubt that one can, to an extent, push a party into mediating. For example, in the family law arena, if I see one more attorney throw out the "we will not litigate by correspondence" maxim, I might just pull my hair out. It's just so common, particularly in the family law field, that the reality is we are there to resolve disputes, and we're there to resolve them effectively. And there is one of my practice managers shouting in the background. Sorry for the noise with the dogs. But the reality is that one can push parties into mediating. And it's not good enough in the current climate with our Rule 37, our Rule 37A, and Rule 41 to just throw the maxim out and say, well, we're not litigating by correspondence. We'll deal with that when we get to trial. And I think attorneys are going to find that they're going to have a very, very tough time when they get to the steps of courts, to just simply say, well, we weren't prepared to mediate. We didn't believe there was benefit in it. There are going to be explanations that are going to need to be made. So in terms of that, and in terms of mediating or mediation being shown to be the weak alternative, there's a perception out there that needs to change, that you have to be this tough, hardcore litigator in order to, to show your worth. It's just parties are moving towards mediation. There is a move towards it, and the courts are helping us along. So I would ask the profession out there, if you're feeling that getting a trial date is the only means of resolving your dispute, 41A and Rule 30A are going to help you bring mediation into your practice. And the D-Day of that mediation date really is bringing about results. We've seen it in the pilot projects, in the road accident fund and the clinical negligence matters. The fact that there is a mediation date around the corner is pushing parties to effectively look at the matter. And I think it's going to be a way to resolve disputes outside of trial. So what I want to talk a bit about is bringing mediation into the legal practice. Now, first and foremost, Rule 41A2 requires the parties to say whether they're prepared to mediate or not. I have found in the litigation space that many attorneys, and in fact, even established attorneys, I'm not getting my 41A2B elections from defendants. So I will then say, you need to make that election. Are you prepared to mediate or not? And some parties, and I've had some reasonable 41A2B notices saying, well, we're not prepared to mediate because we simply, there are certain issues in dispute which are not resolvable by mediation. There are fundamental principles upon which we disagree. And one mustn't forget that you know, not all parties are able to mediate. The reality is not all matters are capable of mediation. But 41A2 for me is a biggie. Then we've got 41A3, which says that the parties can agree to mediation. But the question arises as if you've got an opponent who hasn't even made an election, what do you do? What do you do to bring this to the fore? And we have Rule 30A, which is a huge help. And I do believe that the key to mediation and the key to 41A mediation is going to be Rule 30A. Now, Rule 30A says that if a party fails to comply with the rules or request made in relation to that, that they can be compelled to do so. So 30A does require you to put your opponent on terms. You do need to give them 10 days within which they can you know, rectify the defects. And if they don't, you can then use Rule 30A to compel the party to comply. Now, the reason I place so much emphasis on Rule 30A is there's an interlocutory court, and your access to interlocutory court is a lot easier than your motion court in the mainstream. So what I would say is if you want to bring mediation in and your party hasn't made a 41A2 election and they ignore your requests, bring an application to compel that election. Because the reality is your opponent is then going to have to come and they're going to have to set out reasons for their refusal. And there is a caution there that those reasons are going to be scrutinized. So use your Rule 30A. I've had situations where if there is no election, I will combine Rule 41A3 and Rule 41A2, and I'll bring an application compelling the party to either mediate or to provide adequate reasons for their refusal to mediate. And I can tell you now that it's been shown in courts across the country. The courts are wanting to help. The courts are wanting mediation. The courts are wanting to alleviate their trial roles. And one of the easiest ways to do that at the moment is most certainly by bringing it. So you really need to take, and I talk to the attorneys out there, take a look at Rule 30A and use it in conjunction with Rule 41A, particularly in the early stages. You know, in your later stages, you know, there's a whole process involved. And mediation should take place within 30 days. If you find that parties are using the mediation process as a delay tactic, you can bring an application to court and you can use Rule 30 subsection A. You say, right, we've asked to mediate, but now there's delay. We want the parties to agree, or they must then step back and tell us why they refuse to mediate. So it's really so interwoven with, you know, with Rule 30 subsection A. And the directives, you know, the directives to an extent are again, particularly in Y category cases, preventing access to the courts. This might not be what the intention was, but the reality is, you know, to jump through hoops to get to the steps of court where there is in fact an alternative path. I think it's going to really open up the door for mediation, and parties are going to start looking at alternative dispute resolution simply as a means to get their opponents to appropriately prepare, address, and look at settling the matter. So I know that there was a very useful conflict dynamics slide, and I haven't been following the slides, but just in terms of reorientating, rebalancing, and recognizing the fact that there is another process open. You know, the litigation process is sometimes a flawed process. Litigation is sometimes fraught with ego. And I think that in relation to that, you know, especially legal representatives, they want to consider, you know, how useful it is to rebalance, to possibly place focus on another form of dispute resolution rather than the adversarial approach, and to know that the courts are going to help you. Michelle's going to talk about the mediation space, but the reality is the courts are helping in bringing mediation into the mainstream. So I think maybe I should stop there and see if there's any inputs, and you know, maybe Felicity, you've got, I don't know if there's anything in the chat, but it's positive. All I can say is that, you know, Rule 30A in conjunction with 41A, it's a good tool to bring mediation into your practice.
Thanks, Lee. I think let's just go on to the next slide, which is the duty to advise your client, because there are some questions that sort of point in that direction, and particularly in relation to costs. So I'm looking at Radhika Singh's question. the second part, in an answering affidavit, could defendants argue damages, i.e. financial costs or loss of time for not adequately engaging with this rule or even speaking about mediation?
Yeah, and the question is absolutely. Absolutely. You know, we remember we've already got the Brown-Lee decision, and that's not a new decision. It comes from 2008. It was a family law matter where the judge showed, it was Judge Brassey, and the court showed their disapproval of a failure to mediate. And they said, you know, these issues could have been dealt with. They could have been dealt with earlier. And it's just so sad that you've had to come to the steps of court and incur all these costs. And what they did what the judge did in the Brown-Lee decision is they actually made an order that each party was to pay their own costs to show disapproval. So there's absolutely no doubt that Rule 41A and your 41A2 notices are going to be crucial when it comes to arguing costs. And attorneys are going to find themselves with the short end of the stick if it's not considered appropriately. There's absolutely no doubt to that. In relation to advising clients of mediation, you know, attorneys are going to have a tough time if they haven't advised the client that there is that possibility of mediation. If they get to the steps of court and the judge questions, well, was this done? What happened? I mean, did you parties consider voluntary mediation? Did you consider mediation under Rule 41A? For me, the lines are going to become very blurred in relation to private mediation and Rule 41A mediation. So most certainly, there's no doubt in my mind that it's going to be a solid cost argument when you get to the steps of court and all of a sudden you find that an offer is forthcoming when it could have taken place a year or two before.
Yeah, and Radhika makes the point in the Q&A about the experience in the UK, and I think that which is extensive in relation to costs, very well established precedents that if parties do not take these types of rules and the idea of engaging in settlement discussions early seriously, they will be penalized. And so just a little punt for our conflict dynamics course. We have next week on the 25th, our mediation advocacy course. It's a day-long course. And on the course, our trainers talk about those precedents. There are some other precedents in South Africa as well, the Brown-Lee one and some other ones. We're waiting for some precedents to really get this going, some new cases, but it's well established in the UK, and we will talk on that course about those potential risks.
I see, Felicity, that I don't know, I think Michelle might be covering the objectivity issue in relation to mediators. Is Michelle covering that aspect about the fear of objectivity?
I think Michelle probably will just talk about the role of the mediator. Yeah.
Okay.
Yeah. All right. Well, I think thanks very much. I want to just stick with time somewhat, and so go to Michelle. There are a couple of questions that we might come back to. I'll just sift through the ones we've got on the screen. Perhaps actually, Lee, before you go, Viraj Srikishan has got a question. Does Rule 30, Section A affect the voluntary nature of mediation?
Well, I suppose the question is, it's a double-edged sword. Mediation by nature is a voluntary process. And is one forcing a party to mediate? Now, I don't think you can force a party to mediate, but what you can do in requesting those reasons is give a very, very stern caution about a possible adverse costs order. So no, it doesn't necessarily affect the voluntary nature of mediation, but it pushes your opponent into a corner to provide proper, coherent reasons for their refusal.
Yeah. And I think a point we make a lot in conflict dynamics mediator training and advocacy training is that no one is compelled to settle. So your ongoing participation in the mediation is voluntary. Your decision to sign up to an agreement is voluntary. The only bit of voluntariness that is perhaps questionable is providing the reasons and coming along in the first instance. So, people must provide reasons, and if those reasons are compelling for it not to take place, well, there's the voluntary kicking in. But if they're not compelling, then they do need to consider explaining later why they haven't come in. So
If I may interject as well, Felicity, it will also depend on the type of matter, the subject matter of the litigious matter in front of court. Currently, there might be more at the moment, but currently there's about 35 acts that provide for a mechanism of mediation. So it's also very important when the legal practitioner takes the instruction to have a look at the applicable legislation, and then see if this is a matter that actually needs to be mediated in a certain fashion in accordance with the specific act that's applicable on the matter at hand. So that's also a very important consideration to take. Commercial matters, for instance, you will look at different kind of banking laws. There's also the ombudsman that comes into play. So there's different processes that needs to be followed. So the attorney or the legal representative needs to understand the matter at hand before advising the client accordingly as well.
And in fact, in the book that John Brand, Chris Todd and I wrote some years ago, we identify at least 50 pieces of legislation where mediation is already mentioned. So Lizelle makes a good point there that there's mediation is really systemic in our system, and it's now a case of making it happen. Okay, so Michelle, over to you.
Thanks, Felicity. So Lizelle has given you an overview of the rule, and you've seen it through the lens of an attorney with Lee. I'm now going to put the lens of the mediator on and take you through how a mediator handles the process. So once a joint minute has been filed at court, this is the minute indicating the parties' agreement to participate in the mediation process. The next step would be for the parties to select a mediator. The most important part of the selection process is ensuring that the mediator you are considering is suitably accredited and experienced. When I talk of being accredited, I mean trained by a reputable and recognized service provider. A typical training course is a minimum of 40 hours and should be an accredited training course. So you need to just make sure that you are dealing with someone who has attended one of these accredited training courses and has the necessary accreditation themselves. Apart from accreditation, experience is also very important. Experience means they have some background in the subject matter of the dispute and then sufficient mediation experience. The mediation experience is important as there are many trained mediators, in other words, who have completed the 40-hour training course, but because mediation is not yet prolific, they may not have experience. So just check both of those aspects when you're considering somebody. Are they properly accredited and do they have sufficient experience? Don't be shy to ask for a mediator's credentials. See it like appointing your counsel. You're looking to choose somebody that's suited to the parties and to the dispute. So in time, when mediation develops into kind of a fully fledged practice, it will be important for practitioners to have a handful of mediators that they work with and then select the appropriate mediator for the parties and for the dispute. On a practical level, when one is looking for a mediator, there are three routes you can follow. If you can see it as three tiers, there's an umbrella body that accredits mediation service providers called DISAC, the Dispute Settlement Accreditation Council. And then the mediation service providers sit under that umbrella body. And then the individual mediators either mediate on their own or through a panel like Conflict Dynamics. So when you're looking for a mediator, you can start at the first tier and approach somebody that you know directly, being sure, as I said, to confirm accreditation and experience. Or you can contact a service provider like Conflict Dynamics to provide a list of suitable mediators that you can choose from. Service providers also generally display the mediator's profile and credentials on their website, so it makes it easy for you to just scroll through and see if this person looks like somebody who's appropriate to deal with your dispute. If you're not sure about a service provider or a mediator, you can contact DISAC directly and they will confirm on request whether a certain service provider or mediator has the necessary qualifications and expertise. So once you've selected your mediator, another thing to bear in mind is that one of the benefits of mediation is that if the dispute you are referring requires particular expertise, for example, financial or medical or engineering, the parties may agree to appoint a co-mediator with the requisite knowledge. So this is an important distinguishing factor of mediation. The process is flexible, as Felicity said in the opening. So you can bring subject matter experts into the process if this may assist the parties in finding a workable solution. So remember that that's an option when you are appointing your mediator. Consider whether a co-mediator would be appropriate. Once you've made that selection and both parties agree on a particular mediator, the next step would be to approach the mediator and start the mediation process. Many mediators will start that process by inviting you to an online pre-mediation session, and I like to do this. It's like having a pre-trial conference or a pre-arb conference. And that session is an opportunity for the parties to meet one another and the mediator, for the mediator to explain the process and address queries or concerns. It also enables the mediator to manage expectations, particularly with legal representatives and what their role is, and just reminding them that the parties may also participate. So all those kind of issues can be sorted out. Gives you the chance to distill issues, establish if there are preliminary things that need addressing, can deal with the exchange of documents and how the mediator wants opening statements to be done. And then at the end of that pre-mediation meeting, or the end of it will result in the conclusion of the mediation agreement. The mediation agreement is the instrument that deals with the appointment of the mediator, the terms of reference, an outline of the mediation process, and fees. And most mediators and mediation service providers have a standard agreement which deals with all those things. Importantly, that mediation agreement records the duty of confidentiality that all parties to the mediation process are bound by. So one of the things that it deals with are fees, and I just want to touch upon fees because people who are considering using mediation might be wondering, you know, what does this cost? Like counsel, all mediators charge their own rates, but generally I would say somewhere between 12,000 and 18,000 per day or per mediation. So some mediators charge per day, others charge an all-inclusive fee per mediation. Typically this fee is split between the parties equally. So you're looking at between 6,000 and maybe 10,000 Rand per day or per mediation. Most commercial mediations will finish in one day, but may need 2 or 3 sessions depending on complexity. Right, so once you've concluded the agreement to mediate, the mediation can commence. And another huge advantage of mediation is that the proceedings can be scheduled as soon as all the relevant parties and the mediator are available. It can also be conducted via online platforms like Zoom or in person. And many mediators have been conducting many mediations in this last while using Zoom, and it works exceptionally well. There's a facility for private breakout rooms, which makes it easy for the mediator to have confidential discussions with the parties. So that facility makes it very conducive to mediation. Obviously, in person is always better, but Zoom does work really well. There's also some interesting research coming out that parties on Zoom may be more likely to settle, as seeing themselves on screen may make them more reasonable. Right, so once you've scheduled your mediation, depending on how the mediator wants to handle it, each of the parties may prepare and send to the mediator in advance a brief summary, setting out their main concerns and whatever issues they want to highlight to the mediator. And then the mediator will ensure that all documents are exchanged beforehand so that on the day the mediation is ready to proceed. In the mediation room, once it begins, each party will give a brief opening address. And then once the issues are defined, the mediator will assist the parties generate possible solutions and work towards finding a mutually acceptable outcome. Now, in the chat, there was a comment from Antoine who said people like litigation because they like defending their positions, and a mediator should do a lot of reality testing and wear the parties down, as it were, to try and make them take a more realistic view of their matter. And any mediator worth their salt will not accept entrenched positions and will work very hard to get beyond those positions to the individual parties' interests and needs. So Antoine, yes, good point. So all these discussions and generating options and finding possible solutions may be conducted with the mediator in a joint session, or the mediator may decide it's more appropriate to break into the breakout rooms or private sessions and speak to the parties individually. Again, very important, and I can't stress this enough, is that the mediator respects confidentiality and does not disclose to the other party what is discussed in private unless specifically authorized to do so. So it's a lovely process, and it's an opportunity for parties to engage with the mediator, knowing that what they're saying is protected if they want it to be. Also, all discussions are non-binding, so parties are free to explore possible solutions without being bound by them until agreement is reached, reduced to writing, and signed by the parties. The rule provides that the mediation process must be concluded within 30 days of the signature of that joint minute. So once you file the minute at court indicating you agree to mediate, all of the litigation processes are suspended and the parties have 30 days within which to conclude the mediation. If the parties need more time, the rule does provide that you can approach a judge and ask for an extension on good cause. But other than that, you've got 30 days to conclude and then file a joint minute to the court indicating that the matter has been concluded. So just to clarify, the mediator doesn't sign a certificate like the CCMA of resolution or non-resolution. The rule requires that joint minute is filed, signed by the parties and the mediator. So I want to end my presentation with a call to action to everybody on this call. Those of you that are attorneys or counsel, don't wait for pushback from the courts or adverse costs orders before you embrace Rule 41A. I encourage you to consider and to make the use of the opportunity that the rule presents to you. It's a tool that wasn't available to you before, and it puts you into a unique space with your opponent, affording you a lens not only into their case, but into their attitude towards their case, which can give you as a practitioner very important insight into how best to manage the process and to manage your client's case. Also, always good to remember, the danger lies in not knowing what you don't know. There are always two sides to the story, and you are operating as a practitioner only on one side and one version of what your clients told you. There's more to the picture, and mediation gives you the opportunity to go into a space where you can understand from the other side how they see the dispute, and then you can start to figure out how to resolve and to find solutions that both parties are happy with. So learn to use mediation strategically as an additional means with which you can better understand the other side of the coin and to get what your client actually wants. This may not be the relief sought in the particulars of claim or notice of motion. It may be something different, and mediation offers your client the opportunity to explore different outcomes. Causes of action in a litigation space are very limited, and the relief that you can seek is even more limited. So mediation opens up this whole world of possibilities of different solutions that may be more appropriate and may satisfy your client more. It gives your clients a voice, an opportunity to be heard and understood in a non-threatening way. And for this reason, when matters settle in mediation, settlement agreements are extremely rarely not complied with. Because clients have participated in the process, understood where the other side is coming from, and bought into the process and the agreement, it's very rare that you see settlement agreements that have been mediated not complied with down the line. So mediation expands the scope of resolution and should be seen as an additional tool in your toolkit to use strategically to your advantage and to your client's advantage. It's safe, it's confidential, and you have nothing to lose and everything to gain. Thank you.
Thanks, Michelle. Well, we hope your enthusiasm is picked up, and that I just know from gosh, 30 years of mediating, that the outcomes you can achieve in a mediation can be, and you know, the point you make, can be so much more meaningful for your client, and can address things that a court cannot address. You know, it can provide reasons, it's an opportunity for apologies, it's, you know, all sorts of things, and parties often haven't even seen one another, for ages by the time they get to court. So they, you know, they really are pitched against one another. Whereas mediation gives them an opportunity to see one another earlier and actually get out of those trenches and find solutions that save them a lot of time, money, and emotional drain and strain. Just a couple of questions, Michelle, if I may. So you mentioned in that last slide the notice and the joint minute that the mediator signs. I just want to check with you. All the way through this process, there are various notices and things that have to be submitted. Am I right in saying that the only document that the mediator, there are two documents that the mediator signs. So one is the agreement to mediate, and the other is the joint minute at the end of the process, which doesn't contain the settlement agreement, which they also don't sign, but it sets out whether agreement was achieved or not. Is that right?
Correct. That's absolutely correct. Yes.
Yeah. And does the mediator issue a certificate, or could a mediator issue a certificate? You know, people are so used to those CCMA certificates.
There would be no harm in issuing a certificate. The court wants it in the form of that joint minute, and I would imagine that would be the court's reference. But for the parties themselves, if you want to issue a certificate saying that they've participated and either resolved or didn't, there would be no harm in doing that.
Yeah.
But the rules very specifically requires that joint minute to be filed, and that's the format in which the court wants it.
Yeah. And you made the point that the mediation process is confidential and without prejudice. So to what extent will the court know, either through the joint minute or through the settlement agreement, the actual details of the settlement?
If so, the court won't know at all what went on in the mediation. The only document that could be produced at court would be the final settlement agreement and the terms of that settlement agreement, and that agreement can be made an order of court. So other than the settlement agreement, the court won't be able to go kind of into that mediation space at all, and be informed in any way what happened.
And you use the term non-binding, and sometimes people think, oh, well, you know, mediation's like counseling sort of thing. You know, we're just going to have a chat, and if we reach agreement, well, we don't have to actually go along with it. But now you've talked about an order of court. So I'm assuming that a settlement agreement becomes a contract.
Absolutely, absolutely. So the non-binding is while you're having your discussions and you are throwing around options, and you may get a partial agreement that you're exploring, but none of that is binding until it's reduced to writing and signed. So it's a very safe space for you to bandy back and forth options, but you're not bound by them until there's a full agreement and it's reduced to writing and signed.
Yeah. Okay, great. Lee made the point in the chat about preparation costs, and so this is in relation to the fee, and you gave some indication of fees. Typically, how is preparation dealt with from a cost point of view, and you know, how long is a piece of string on preparation?
Yeah, so again, it's like counsel. Different mediators will charge in different ways. Some counsel charge an all-inclusive fee for their appearance in court, which includes preparation. Some mediators will charge an all-inclusive fee. Some will charge an hourly rate for preparation, especially if it's a complex matter. But all of this would be disclosed and agreed up front in the agreement to mediate before the mediation starts.
Yes. Yeah, so that agreement to mediate, and just speaking from a conflict dynamics point of view, the contractual arrangements between the provider, the mediator, and the client and the parties is very important. So there's no misunderstanding about how much time will be taken and how much that will cost. In conflict dynamics, I think I'm right in saying, Marion can correct me, we offer I think it's 2 hours preparation as part of the fee. And the mediator knows that, they're bound by that. And if it requires more preparation, then they will say so and get permission to spend more time. Okay, well, there are quite a few questions that have come through. And so let me look at them. There's Radhika's question about settlement agreement automatically becoming an order of court on presentation. I think you've dealt with that. If it's presented to the court, it would become an order?
I don't think it would be automatic. One would have to make an application to make the settlement agreement an order of court. Lee, would you confirm that?
Most certainly, you know, if you've got a settlement agreement, you can always go to the trial date and have it made an order of court, but it's not automatically made an order of court. One of the problems with court orders at the moment is the settlement roll. For example, in Pretoria, the settlement roll is non-functioning. But, you know, would it necessarily need to be made to an order of court in order to enforce it? No. If the parties fail to perform in terms of the settlement agreement, one could apply to court. But it doesn't, you know, there's no necessity for it to become an order of court either. But no, most certainly not automatically. One would have to apply. Right.
There are a couple of questions from Antoine. Maybe I can just deal. No, there's, let's see. Antoine says, from a litigation point of view, what would be your answer to the concerns of the opposing party tailoring their defense and testimony based on the statements made in the mediation, and since it's confidential? And how does one show the discrepancy and get parties to participate fully due to that concern? Yeah, so parties come, you know, and it's always been an issue, coming to mediation as a kind of fishing expedition, and then using what they've heard. How do you deal with that? Any of you?
So I think that's where the skill of the mediator comes in. It becomes quite clear quite quickly when a party is doing that. And I think I would maybe take the party aside and say, look, you know, are you mediating in good faith, or are you just here because I'm not going to indulge a fishing expedition? So yeah, again, that's where the skill and the experience of the mediator comes in to handle the process and manage it.
Mm.
And it would also become a question of law of evidence. Sorry, Lee, a question of law of evidence. So, you know, in a technical sense, the legal representatives will then be able to also block information that was not rightfully obtained during the mediation itself.
Mm. Lee?
I just want to highlight what Michelle said about the skill of the mediator, because it's so true. You know, in the mediation context, I would take the parties into a private meeting. Very often, there's information which is helpful to the mediator, which can be shared in a private meeting, and one can then utilize that to appropriately reality check in a private meeting with another. So, you know, again, it like Michelle says, it definitely comes down to mediator skill.
Mm. And really, one of the skills of the mediator that we teach on our mediator training is negotiation coaching. So, you know, you're working with the parties to help them put their best foot forward in the mediation. And if they, you know, if they're wondering about whether to disclose certain information, you're going to, as Lee says, say to them, well, what if you did? What if you didn't? What impact would that have later on? Or could it have later on? So you have all those conversations. You're not a messenger, and you're not compelled to get an answer to a question from one room to convey to the other room. You have those conversations. And that's why, as Michelle said, an experienced mediator who knows how to actually work with the subtlety of those negotiations is really important. There was a question, oh, it's just disappeared, about accreditation. Yes, okay, so I see Michelle has answered that for us, thank you. Marion, yeah. Sorry, Michelle, go ahead.
There's a question again from Antoine about if the case is against public institution and the decision makers are not at the mediation. And this goes generally to settlement authority and mandates. And that's something that the pre-mediation meeting is very useful for, is to establish who's going to be in that mediation room and ensure that they have the necessary mandate and the necessary settlement authority, because if they're not, you're wasting your time. You're right. Yeah.
And in fact, the agreement to mediate should contain a clause to which everyone signs up to, which is that they will come with authority to negotiate. And in your pre-mediation calls, you're going to talk to them about that. And if they say, well, unfortunately, the CEO can't be there on that day, and that is the ultimate decision maker, then you would have a conversation about whether to go ahead at all on that day, or whether the person might be available on the phone to contact should an offer be made. That would be worth considering. Marion, you made a point about in your questions about box ticking, and we've already had that point made by others, and so my question to our three panelists is how do you think we're going to make sure that people don't just come along to a mediation in order to tick a box, but to actually take it seriously? So, for example, the kind of thing we experience is parties saying, oh, why do we need a whole day? Surely we only need an hour or two. This is not going to take very long, either because they don't believe it's going to settle, or because they believe that their case is so strong, or they don't understand mediation. So we're adapting our practice to quote on an hourly basis rather than a whole day, but also to make the point that people need to be flexible and be prepared to stay longer. But what could you do, let's say, as an attorney? What could attorneys do to ensure that the other party is not just coming along to tick a box? So Lee, let me ask you that to begin with.
I think it is a difficult one, and you're always going to have attorneys who are coming along to tick the box. It's hopefully as mediation pervades our justice system more and more, the fact that it is a useful tool will actually help in that. But one also has to bear in mind, if I have an attorney, for example, who says to me, well, you want mediation just to delay. Well, it wouldn't really happen too much to me because I'm on the plaintiff side, but remember, the onus is on the party to prove that delay. So Rule 41A does provide relief. If a party feels that mediation is being used solely for the purposes of delay, or they feel that the parties are not being, genuine, Rule 41A actually does provide the opportunity to bring that to court and to ventilate those concerns at court. So Rule 41A does provide some relief, but at the end of the day, you're limited. An attorney has to want to resolve the matter for mediation to be effective.
Yeah. Zell or Michelle, do you want to add to that at all from your perspective?
Yes, Felicity, I think that's where the mind shift, when we do training, legal training, and we train our young legal minds to train them in the sense that they should have a viewpoint of trying to first settle a matter, and if the matter really cannot settle, then there's always room for litigation. You will always have the real matters that really needs to litigate will always litigate, but then you'll have to have that mind shift in how you approach your matters when you first receive your instructions. I think that would be the key.
Yeah. Michelle, anything to add?
No, nothing to add. Thanks, Felicity. There's a really nice question from Pearl Biela. I don't know if you've seen it.
Yes. Would you like to tackle it?
Well, I was hoping Lee would. I'll read the question. How does one determine which side of the thin line does a party's failure to enter into the negotiation process fall under the ignorance of the party and the attorneys, or if it's mala fide reasons? Yeah.
Well, again, a difficult one, but remember, and this is where I think attorneys are going to come unstuck, is it's very easy to throw reasons out in the beginning stage and say, well, I'm not prepared to mediate for this, this, and that, or I am prepared to mediate, but those reasons are going to be scrutinized down the line. And I think that court decisions are going to come out and precedents are going to be set, and it's going to result in attorneys exercising a lot more caution. So unfortunately, it's early days, but I tell you what, it's going to happen. So, attorneys just have to realize the reasons are going to be scrutinized down the line.
Great. Well, we haven't got much time left to go, so I wanted to draw things together with a couple of points. There have been quite a few points about accreditation, and Michelle has very helpfully been answering them furiously in the background. And so just to clarify, and again, a bit of a punt for conflict dynamics. Conflict dynamics is a training provider. So, and we have been accredited by DISAC, which is an overarching body. There are other training providers, a number of others. People are very familiar with Tukiso, for example, Equitate, which Michelle is involved in as well. And those training providers all are working together now to establish, there was a question about SACWA, and they're working together with DISAC to establish a professional body. It's a huge amount of work to get it done. If anyone has established a professional body, you'll know. And Marion Scher on our team has been working very closely with the task team there. So we hope to have a professional body, but in the meantime, it's DISAC and then accredited providers and accredited training organizations. So Conflict Dynamics is also an accredited provider of mediators. And once you become trained and accredited by Conflict Dynamics and join our panel, you can go on and become DISAC accredited. And Craig's put up the DISAC website, which is very easily accessible. And then Conflict Dynamics also offers the possibility of accreditation through the Centre for Effective Dispute Resolution in the UK, SYSTE. And also because we've been accredited by the International Mediation Institute, you can become qualified or recognized as qualified or certified by the IMI. So there are all sorts of layers to this. And if you'd like to know more, either as a potential mediator or as a trained mediator, please just speak to us and we can explain it all and navigate it all. And it sounds bureaucratic, it sounds all quite complicated, but it really goes to the point that Michelle made about the importance of quality mediators and quality processes, because really mediation is only so good as the last mediation. And if someone has a bad experience, then they simply are going to be going through a tick box exercise and not taking it seriously. So we'd encourage you to train and if you're in a position to choose mediators, choose properly trained and accredited mediators. I wanted to then just share my screen, Craig, if I can briefly share my screen just to show the Conflict Dynamics website page where we have the mediation advocacy course next week. If you want to find out more about as an advocate or as a representative of a party, what is mediation? How do I work with it? What is this reality testing we've been talking about? How do you do it? And then we're going to have a session for already accredited mediators next Friday on mediating online, just a half-day session. Providing examples of documents and so on. And then of course we have our mediation skills training courses coming up. So feel free to be in touch with us. We will share with everybody the recording. We'd like to share also a wonderful document that Michelle has prepared on Rule 41A, a litigator's guide. And we will share the set of documents that we've prepared in Conflict Dynamics, the various notices and minutes and agreement documents we will share with you, and then a survey just to get some feedback from you on how you have found this. So thank you very much. We have actually 5 minutes to play with, so I'm going to just pick up on 1 or 2 more questions, if I may.
Sorry, Felicity, Marion actually asked quite a pertinent question, and I tried to answer live and somehow messed it up. I can't find it now. I don't know if Marion's able to repost, but it was in relation to a mediator problem, and I can't find it now. I'm just trying to run through the list of questions. I don't know if she's possibly able to repost it.
It's in the answered questions. It has been answered though by Felicity. About
Oh, I see. Okay. Okay.
Yeah. Yeah.
Right.
And so, yes, we've had a couple of other questions like Tommy, once accredited, can a mediator market themselves as a mediator? Yes, you can. As Michelle has said, you can seek direct appointments. Just be aware that it's useful to be part of a panel in order to have access, for example, to template documents, to be recommended. If you're out there, and Conflict Dynamics provides a level of professional indemnity insurance for mediators. If you're out there on your own, you need insurance. If you do something wrong and you don't already have insurance, let's say as an attorney, that covers you as a mediator, you need insurance. So that a panel also gives you opportunities for CPD, for staying current. So it can be helpful. Yeah, you don't need to be an attorney to mediate. You need to understand the litigation, the process, and you need to be familiar, especially if it's a Rule 41A, what your obligations are, which we hope we've given you some clarity on. And also for reality testing, you need to understand as a mediator where this could go to next. So that you can ask the right questions.
Felicity, yes, I think that's a very, very important point. In practice, you would find that, specifically the mediator, when you take on an instruction, you need to know that you know the field, the specific field, because there's certain heads that you would need to address in a typical court order or a typical settlement agreement that would pertain to that specific type of matter. So if you are not a specialized mediator, for instance, in medical negligence matters, you must really know the subject matter as well before you attempt a mediation, and that is why these training courses are so necessary, so that you know that you are up to date and that you really understand the subject matter. Because a lot of times in practice you will find that there might be a settlement agreement, but when the parties then go to court to make it an order, the judge will find that it's not something that can be done in law. And that would not be because anyone was bona fide or trying to do something wrong. It would be because there was not an understanding of the specific subject matter. So it's very important that you select your mediator very well with regards to the specific type of case at hand.
Yeah. Yeah, and you'll see on our website also you can sort our mediators into dispute type, industry type. Lizelle, I'm going to treat that as your last word. I'm going to offer Michelle and then Lee an opportunity for a last word before we close. Michelle, what would you like to leave us with?
Just to reinforce that call to action. Use this process. It's there available to you. It affords you a wonderful opportunity to deal with your dispute in a different way, and embrace it.
Thank you. And Lee?
I'm probably going to echo those sentiments. I've run a very litigious practice for 20 plus years, and I can honestly say that mediation works. So mediation is not a soft alternative. You need to try it. So that would be my ending words, is try it. It'll surprise you.
Mm. And if I could just say in closing that the research, certainly in the UK, where civil and commercial mediation is well established, indicates that more than 80% of the cases settle on the day, in a day, and the balance settle fairly shortly thereafter on similar terms last discussed in the mediation. And a very small percentage don't settle at all. So your prospects of success in mediation are really proved to be very positive. We even know that from the CCMA, which is compulsory, and where parties have been dragged there not because they want to be there. So thank you very much, everybody, for all your questions and for your contributions, and especially to our three panelists and for their insights. We'll be in touch soon with some follow-up documents and look forward to seeing you on a course or in a mediation. Thank you.
Thank you. Bye.
Bye, everyone.